Yes, Simran, please introduce yourself.
Good evening, sir. I have done my BBA LLB from Karnataka University. I'm a graduate of 2017 batch. Pursuant to that, I started preparing for judicial service examination. And so currently, along with my studies, I'm working in Delhi. I'm practicing in Delhi courts, sir.
You are a practicing advocate in Delhi court.
Yes, sir.
In which side, in the criminal matters you are practicing or civil matters?
So majorly civil matters and arbitration matters, sir. And to some extent, sir, I have got a chance to deal with criminal matters, specifically, sir, 138 matters, sir. Not much of a criminal side, sir.
Okay. What is issue in a civil case?
Basically, issue can be a dispute raised by either parties of the suit, which needs to be decided. A dispute, basically, sir.
How issues are framed?
So basically, sir, issues are framed on the basis of the pleadings of the plaintiff, sir.
When preliminary issues is to be framed. When preliminary issue is to be framed.
So preliminary issues, basically are framed in terms of, so let's say, for example, there is a question of limitation. So in that case, the preliminary issues can be framed, sir.
But the res judicata can be a issue of preliminary issue. But the res judicata, on the point of res judicata, whether it will be treated as a preliminary issue.
Yes, sir, as per my understanding, it has to be a preliminary issue, sir.
When a plaint is to be amended,
So when a plaint is to be admitted,
amended.
amended, okay. So basically, amended a plaint can be amended under Order 6, Rule 17 of the Code of Civil Procedure, sir. So when in order to introduce new facts, which was so there are two three circumstances. Let's say first to address a change in law. In that case, the plaint can be amended. Sir, next scenario can be to introduce a new facts which came in light after the filing of the suit, sir. So to introduce necessary facts which are to introduce necessary aspects or bring in the knowledge of the court necessary facts to decide which will be necessary to decide the case between the parties, sir. In those cases, the plaint can be amended, sir.
whether after amendment of plaint, the defendant will be given chance to file further written statement.
Uh, yes, sir.
When documents are to be produced before the civil court,
So, at the time, so basically, documents are to be brought on record by the parties along with their pleadings, sir. In the first instance, only those have to be brought. However, sir, there can be exceptional situations when the court can allow the production of the documents at later stage as well.
what is pleading?
What is a pleading?
What is
So,
pleading?
basically, the pleadings are the case of which the party wants to present it before the court, sir. So, for example, for a party instituting a suit, the pleading can be the plaint, sir, wherein the plaintiff brings forth his case before the court, and so for the defendant, it can be written statement or the counterclaim which the defendant seeks to bring in before the court to defend the suit against him, sir.
What is counterclaim?
So basically, sir, counterclaim is a so it can be treated as a suit which the defendant brings along with the written statement or statement of defense in order to countenance the plaint of the plaintiff, sir, and to put forth his claims against the plaint which he is a
What is the
plaintiff.
difference between counterclaim and set off?
So one difference is set off has to be for an a certain sum of money, and which can be legally set off, sir. However, the counterclaim can be also of an uncertain sum of money, sir. So this is one difference I can as of now recall immediately, sir.
When court will appoint a commission,
Sorry, sir.
when commission will be issued by the court.
Yes, sir. So basically, commission can be issued in various circumstances, sir. So basically, sir, first thing, there are 4 5 circumstances. Basically, the court can issue summons to perform specific tasks, sir. For example, for a partition of a suit, sir, um, for ministerial acts, sir, to sir for the adjudication of an accounts. So I'm not very well able to
What is
recall.
constructive res judicata?
Okay, so basically, constructive res judicata is at the time of bringing forth the defense, a party has to bring all the defenses at the first place only, sir. So basically, sir, constructive res judicata can be the issues which the parties ought to have brought, however, they have not brought in the first instance before the court, sir. So, sir, it will be deemed to be as a constructive res judicata, and at this, the party cannot file another suit in a subsequent point of time to plead the issues which the party could have pleaded in the first instance only, sir.
What is the inherent power of a civil court?
So basically, inherent power of the civil courts, basically can be the powers which have not been specifically given to the courts or specifically defined in the code of civil procedure, sir. However, the courts can exercising its inherent power in order to provide justice to the party, uh, in terms enlarge its jurisdiction, or likewise to give justice, sir.
What is affray?
So what is
Affray.
affray? So basically, FRA is defined in Indian Penal Code, can be defined as a public order offence constituting which constitutes fighting with one or more persons in public place which disturbs the public peace, sir.
And what is mischief?
Mischief.
What is
Sir,
kidnapping?
mischief, sir. I'm sorry, sir. I'm not able to
What
recall.
is kidnapping?
Sorry, sir.
Kidnapping. Kidnap.
Kidnapping. Yes, sir. So, kidnapping is basically taking away. Kidnapping can be confinement of a person against the will without the permission of the legal guardian in case of a minor, sir.
What is wrongful restraint?
Wrongful restraint. So, sir, wrongful restraint is restraining a person to move in a particular direction in which the person has a right to move.
What is wrongful confinement?
And so wrongful confinement is confining a person in the from moving beyond the four corners, sir.
What is kidnapping?
Kidnapping?
Kidnapping.
Yes, sir. So basically, sir, kidnapping is again, so it's an offense wherein a person is taken away from the lawful guardianship of a person, and in case of a minor, sir, it's when a person is taken without the permission of the legal guardian, and the person is under the age of 18 years. In case of a female, sir, and in case of a male, 16 years, sir.
What is estoppel?
So, estoppel is basically an equitable principle which says that uh, if someone on the commitment or assurance of a person does something, and a right is created in favor of the person committing cannot at a later point of time step back from the assurance, or from the Commitment given, sir.
What is the difference between admission and confession?
Yes, sir. So, sir, basically, admission admission is an acknowledgement of a fact, sir. Admission is an acknowledgement of a fact, sir. However, confession is specifically an admission of a guilt, or in other words, admission of a guilt or involvement pertaining to the involvement of a crime. Yes, sir.
What is the document defined under the Evidence Act?
Yes, sir. So, sir, document, so it can be. So I'm not able to answer all of this.
What is fact?
What is, sir?
What is fact?
So fact is a bundle of statement. Is something which it's a bundle of statements which can be perceived by sense or which someone is aware of.
When expert evidence is taken,
So when the court has to arrive to a conclusion in specific subjects like subject of science or art or at times specific subjects of law also, sir, then expert medical evidences, sir, then expert evidence is brought in, sir. In cases of handwriting also, sir, disputes pertaining to the handwriting, expert evidence can be taken.
what is doctrine of respondents?
So, sir, basically, doctrine of lis pendens is when a person who does not have a right to transfer a property tries to confer a benefit on a third. When a person not I'm sorry, so I'll start again. So when a person who not the owner of the property tries to create a transaction and on a third on the transferee and on the other hand confers a benefit on the owner of the property, so in that case the owner of the property has two options, either to adopt the transaction or reject the transaction, so and this is known as the doctrine of election.
What is mortgage?
So basically, mortgage is a right. So Section 58 of the Transfer of Property Act defines a mortgage. So it's an agreement wherein a person gives the transfers the ownership right of a property ownership property in order to secure us a loan, sir.
What is lease?
So, lease is also a transfer of a right on a property to use the property for for a certain fixed period of time, sir, and in exchange of rent or premium, sir.
What is license?
So in license, sir, there is no specific agreement which is entered into between the parties. However, sir, in license, the person grants to other or a certain sum of persons a right to use the property for some time. However, there is no transfer of property or transfer of right over that, sir.
What is actionable claim?
Sir, apologies, I'm not very versed with the concept of actionable claim, sir.
What is anticipatory bail?
Anticipated bail. So, sir, when a person has a apprehension that he or she might be arrested for an accusation levied against that specific person, he can move to the court, so before the High Court or the Court of Session, and seeking that in case of any apprehended arrest, the person be released on bail.
What is the procedure to follow for trial of a warrant case?
Trial of warrant case.
Warrant case.
Yes, sir. So, sir, trial of a warrant case. Sir, sir, it starts from sir section 238 of the Code of Civil Criminal Procedure. Sir, if the first thing which needs to be done is there has to be compliance with the provisions of section 207. Sir, pursuant to that, the when the case comes to the magistrate, and if upon considering the police report and sent to it to the magistrate under section 153, and sir, with further examination of the accused, if required, and after giving the prosecution as well as the accused an opportunity of being heard, the magistrate feels that the charges levied against the person is groundless, so he may discharge it, sir. So, however, if upon examination of the parties and giving the opportunity of the parties of being heard, if the magistrate feels that there is ground for presuming again the presuming in terms of the charges levied, the court can proceed with the framing of the charges, sir. Sir, and pursuant to the framing of the charges, the magistrate first has to ask the accused whether if he pleads guilty or not, sir. And sir, in case of if he pleads guilty, sir, then in terms of his plea, so the magistrate can convict the accused. However, sir, if the accused does not plead guilty or pleads to be tried, so sir, then in that case, the magistrate has to proceed further, and the sir, if required, the magistrate has to record the statement of the witnesses, and in fact, the magistrate then has to direct the witnesses to attend the hearing on the day fixed for both the parties, sir, and then there will be the evidence for both the prosecution. First, the evidence of the prosecution will be taken, and so then the evidence of the accused shall be taken, and sir, and accordingly, the court has to then the
If metropolitan magistrate courts are functioning in Delhi at present,
sorry, sir.
if metropolitan magistrate courts are functioning in Delhi at present,
Sir, I'm not really sure of, sir. Sir, I'm sure metropolitan magistrates will be functioning. I'm not really very confident on that.
anyhow, I want to give some feedback. Issues are framed on considering the pleadings of the parties. Pleadings means either plaint or written statement.
Yes, sir.
Material facts are law pleaded by one party and denied by the other party. From that, issues are framed. Preliminary issue, any issue which will dispose of the case, that will be taken. A particular issue which on the maintainability of the case, that can be taken as preliminary issue. Late amended when it is required for just effective adjudication of the matter in dispute. That is, just decision of the case. Then plaint can be amended, as well as written statement can be amended. Documents have to be produced along with the plaints, with the list of the documents. If the documents are not produced along with the plaint, subsequently any other document will not be taken on the side from the side of the plaintiff as evidence without the permission of the court. That is it. Reading as I told, counterclaim. Counterclaim, while filing written statement, the defendant may make any claim against the plaintiff, either for money or any other property. In such case, the counterclaim will be treated as plaint of the defendant, and the plaintiff will be required to file written statement to the company. Set-off means only ascertained sum of money. In a money suit, set-off can be claimed only for ascertained sum of money. The plaintiff in the written statement may claim that some ascertained money which is legally recoverable from the plaintiff is set-off. Passive sum.
Yes, sir.
Commission may be issued for various purposes, that is, examine a witness, to make local inspection, to make partition, to adjust accounts. All the things are there.
Yes, sir.
To do ministerial work. Constructive res judicata. Res judicata means once a matter has been adjudicated, between a dispute has been adjudicated, then for that dispute there will be no second trial.
Yes, sir.
Whatever grounds would have been taken by plaintiff or defendant as ground of attack or defense, if they have not taken, then it is deemed to have been decided. That is deemed decision, that is constructive. Inherent power, that is gives power to the court, section 151 of the CPC, to pass any order to prevent the abuse of the process of the court or for the interest of justice. That is section 102. Après, two or more persons fight in a public place, disturbing public peace.
Yes, sir.
Mischief, whoever intentionally cause any damage or destruction to the property of another or of the public, that is called mischief. Kidnapping, kidnapping are of two types: kidnapping from lawful guardianship and kidnapping from India. Whoever takes or entices any person from the custody of any, now it is the age restriction is only all 18 years, not below 16 in BNS. Now child,
Child. Yes.
even for male and female, the below age is now 18 years. No more 16 and 18, that is there. Both male and female, an innocent person without the consent of his guardian. Then that is kidnapping from lawful guardians. Whoever takes any person beyond limits of India, that is kidnapping from India, without that person's consent. Conveys any person beyond the limit of India, that is without that person's consent, that is kidnapping from India. Abduction by force or deceitful means induces any person to go from any place, that is abduction. Deceitful by force. Then wrongful restraint, whoever restrained any person to go, proceed in any direction in which has a right to go, proceed. That is wrongful restraint. When a person is wrongful restrained within a circumscribed limit, that is wrongful confinement. Wrongful restrained within a circumscribed limit, that is wrongful confinement.
Confinement.
Then estoppel if a person by his act, declaration or omission has made another person to believe a particular thing, and on that belief he has acted upon, then in a suit between him and that person, he cannot deny the truth of this. That is the rule of evidence. That is the statement. Admission is a statement. Otherwise, you are writing. We suggest an inference to the fact in or relevant facts. Admission is always in a civil case.
Yes.
Confession means the admission of guilty of committing a crime by that person. That is confession. Document any matter expressed or described on any substance by means of letter, figure, mark, or by both the one of those means, or by electronic means. We suggest intention to recording it. With intent to record it. That is the document. Fact, anything, state of thing, relation of thing capable of being perceived by sense or any mental condition which a person is concerned. That is psychological fact and physical fact.
Physical fact.
Right. Expert, when the court has to form opinion on any foreign law, science, writing, etc., the court may take the opinion of a person who is specially skilled in this subject. That person is called expert. Expert opinion is taken. Respondents during pendency of a suit of a movable property can be transferred so as to affect the decree to be passed in the case. Whatever decree is passed, if without permission of the court it is transferred, that whatever decree is passed, that is binding on the transfer.
Yes, sir.
That is mortgage. Mortgage is a transfer of an interest in specific movable property as security for payment of debt or loan. That is mortgage. And lease is a transfer of right to enjoy certain property for certain period in lieu of payment of rent or periodical payment, house rent. That is lease. License is permission to enter somebody's property without which the entry is illegal. That is license. No right is transferred.
Okay.
Actionable claim to any debt other than debt secured by mortgage or hypothecation with the civil court recognize a right to give some remedy. That is actionable. Anticipatory bail, when a person is apprehending his arrest in an unbailable offense, he can file a petition, get anticipatory from the High Court and the Session Court. Warrant case procedure, very you are making it a lengthy warrant procedure. You may try to explain it very briefly. When in warrant case, charges are to be framed. So that is why when the accused is brought, the court will find whether he has received the copies of the police report. Then there will be hearing on the question of point of framing of charge, point of framing of charge. If there is ground for presuming any.
Yeah. So I'm so sorry. I'm so sorry, sir. It got disconnected.
There is no ground for presuming that the accused has committed, and then the charge is to be. Then the groundless, then the to discharge. After framing charge, the contents of the charge will be read over to the accused. Will be asked to plead guilty or not to plead guilty. If he pleads guilty, he may be convicted or may not be convicted, and the court will fix a date for taking evidence from the side of the prosecution. After taking evidence of the prosecution, then the statement of the accused is to be recorded. Then evidence of the defense will be taken, there will be argument and judgment. If a judgment of conviction is there will be hearing on the question of sentence. This is the main difference. Metropolitan magistrate courts are not functioning after the BNSS metropolitan magistrate courts were abolished. Okay. All the similar magistrates are now there throughout India. Magistrate second class, magistrate first class, that.
Got it, sir.
But the chief metropolitan magistrate no longer under BNSS, they are reported. But old matters, old cases, that is there.
Yes, sir.
Thank you. You try to understand because this is a personality test. Your personality test is there. When you do not know a particular matter, you may politely say, "Sorry, sir, I don't know." I may be excused that I don't know. If there no block, that is the thing. Okay, thank you.
Thank you.